Truth Espresso, episode 307.
In a world gone bonkers.
It is not, generally speaking, unruly, but fires have been started and...
Where the culture is a dumpster fire.
We're coming for your children.
And churches have lost their way.
I am really uncomfortable with the story of the crucifixion.
It's time to wake up with Truth Espresso.
Truth Espresso.
Your weekly shot of truth. And now your host, Daniel Minnick.
Well, hey there, friends, family, foes, and lurkers alike. This is your host, Daniel Minnick, for another exciting episode of Truth Espresso. And this is episode 5 in the Manhattan Madness series, the New York Trump trial. When last we discussed this case, it was from last week, in fact, with episode 4. We had heard from the defense witnesses in the case, such as they were, and then the closing arguments, and the jury were left with the instructions to start deliberating. So this episode, I want to get into really what the charges were all about. I talked about that a little bit on the first episode of the series, but in this episode, we're really going to get into it because we're going to look at some parts of the jury instructions. We'll walk through that some, so we'll see exactly what Trump was charged with for the verdict, and then we'll see some of the aftermath of the verdict. So the jury were given instructions for deliberation that began on May 29th, and I will provide a link to the PDF file that is what the jury read that the judge had given them as instructions for deliberating and guidelines for their verdict. So Judge Merchan told the jury to leave their biases at the door, as if that were possible, because we recognize that this case was about Donald Trump. And everyone knows who Donald Trump is, and everyone has an opinion about Donald Trump. So when you have jury instructions that tell you to leave your biases at the door, it's kind of hard to wonder how people will be able to do that, especially when we're talking about a jury of 12 people from Manhattan, New York. Now, it's nice for the judge to suggest that to be fair and balanced, and I'm sure that's what most jury instructions will tell you, but how is it possible with one of the most famous and infamous and polarizing figures in the entire world? Judge Merchan told the jury to consider only the evidence of the facts presented and then any inferences from those facts. Standard, fair jury instruction stuff there. Now, in full disclosure, I did serve on a jury a little over a decade ago as of this recording. It wasn't on a case of this high priority or with any well-known figures, but I do have a little bit of experience having been on a jury and having to reach a unanimous verdict. And it wasn't something where I had to show any bias or feel coerced into anything. The jury members talked about the evidence, and there were 2 charges in that case having to do with real estate fraud, and I thought that the defendant was guilty of one charge and not of the other. After discussing it, I was convinced that the defendant was guilty of both charges, and so that was the unanimous verdict that we all reached. Judge Merchan also told the jury not to speculate about redacted portions of documents. So if a document had some parts whited out or blacked out, whatever, they should not try to imagine what would go in there and have any of that influence their verdict. There were limiting instructions for how to evaluate or limit defendant guilt for American Media Incorporated, credibility for Michael Cohen, and Wall Street news articles and hearsay items for contextual information. Judge Mershon explained that the defendant is assumed innocent until proven guilty beyond a reasonable doubt. Again, great. It's hard to tell if a Manhattan jury could do that with Donald Trump. In the jury instructions, Judge Mershon also talked about how proving beyond a reasonable doubt kind of lies between the unknowable standard of beyond all possible doubt and the much lower standard of probably guilty. This should be based only on the evidence and not for any other reason, such as bias, emotion, consensus, or to finish the jury. So someone on the jury shouldn't feel coerced into agreeing with other jurors because, I want to get home in time for dinner or something. I want this trial to be over. I'm getting tired of it. Judge Mershon's explaining that should never be a reason for any jury doing jury duty to reach a particular verdict. Again, great. No problem with that. There were instructions about evaluating witness motives, lies, or prior criminal records. There were also instructions for evaluating testimony consistencies and inconsistencies. And Judge Mershon also explained that the defendant isn't guilty if he merely witnessed a crime, but that he participated in the crime and had the intent to commit the crime. Standard fair stuff, no problem with that. And then page 27 of the jury instructions begins detailing the felony charges. So with the heading, falsifying business records in the first degree, 34 counts. He explains that intent is inferred from words and actions, not from mind reading, of course. Intent to defraud can have a purpose other than to extort money, which of course is the case with the hush money. Like the intent to defraud can be to cover up a story that you don't want published, not just to get money out of someone. Because in this case, it's paying money to someone. Intent to commit or conceal another crime doesn't require proof that the other crime happened or was successfully concealed, only that the intent was there. So, yeah, a lot of this makes sense and don't have any problem with that. It just kind of shows the scope of what we're dealing with these particular charges. Now, then Judge Mershon in the jury instructions gets to what he calls the predicate to the other crime. So the predicate to the possible crimes was that Trump's business records were to cover up a conspiracy to promote or prevent election under New York election law section 17-152. And I will read from that statute. These statutes are pretty short. They're usually about one paragraph. So New York election law section 17-152 says, quote, conspiracy to promote or prevent election. Any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted upon by one or more of the parties thereto, shall be guilty of a misdemeanor, unquote. And so the statute is saying that the crime here is a misdemeanor. And of course, any type of campaigning, as even Trump's attorney Todd Blanche argued, when you're campaigning for public office, by definition, people are conspiring to promote the election of this candidate. And so the statute makes it a misdemeanor if it's done by unlawful means. So this term unlawful means is critical when it comes to the charges brought against former President Donald Trump. And I'll provide a link to this New York statute in the show notes. So remember from what we talked about a few episodes ago, falsifying business records under the other New York statute are by default misdemeanors unless they are to cover up another crime, which in this case is the conspiracy to promote or prevent election. And what does the statute say about it? It says that the ones who conspire to do this by unlawful means shall be guilty of a misdemeanor. So, falsifying business records are misdemeanors unless they are to cover up another crime, which is another misdemeanor, but the result is now a felony? I guess so. I won't dispute that. It's just interesting how someone could actually commit the misdemeanor of falsifying a business record in the second degree, unless it's some accounting mistake. I mean, wouldn't falsifying a business record usually have some reason other than merely to falsify a business record? Usually that reason would itself be a crime, unless somehow it was an unethical reason that slipped through the cracks of other statutes, or maybe there's a failure to convict someone on the allegations of the other crime, and so therefore it ends up by default being falsifying business records in the second degree, which, remember, just falsifying business records itself in New York is a second degree offense, which is a misdemeanor. But it becomes a first degree, which is a felony, if it's done to conceal another crime. And in this case, according to the charges, the other crime was conspiracy to promote or prevent election by unlawful means, which of course is a misdemeanor. So you commit a misdemeanor to conceal another misdemeanor, and then that elevates the first misdemeanor to be a felony. Now, about that conspiracy to promote or prevent election statute. When this was enacted, was there any concept that simply paying people not to say certain things, allegedly to help one's own chances of getting elected, was that a violation of this statute? Is that what this statute is geared towards? I don't know, but here we are, and that's what the charges are. That Trump violated one statute, and that statute's a felony because it was with the intent to conceal violating another statute. Both of them by themselves are misdemeanors. But if you do one misdemeanor to commit the other misdemeanor, the first one becomes a felony. Now, Judge Merchan continued in his jury instructions. I'll read a part where he says, quote, "Although you must conclude unanimously that the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you need not be unanimous as to what those unlawful means were," unquote. So, the question of whether the charges, remember the original 34 charges that Alvin Bragg brought were felony charges, not misdemeanor charges. And so the charges were that all of these 34 counts, each of them being a document, a business record related to the hush money payments, that these become felonies because they were done to conceal the crime, which itself would be a misdemeanor, of conspiring to promote an election by unlawful means. So, is he guilty of the actual statute of conspiring by unlawful means? Do the hush money payments qualify as the unlawful means, which makes this an actual crime? A misdemeanor, no doubt, but a crime. That's the question here. So, remember, first, the charges are that he falsified business records to conceal the crime of conspiring to promote an election by unlawful means. And now we're trying to figure out what those unlawful means were, because anyone can conspire to promote an election. That's just normal campaigning. But if it's done by unlawful means, now we have to figure out what those were.
Hello, this is Keith Helsley of Quest for Truth.
And I'm Nathan Caldwell.
Together, we talk about worldviews.
Things that affect our pop culture today.
We role-play the viewpoints represented.
We sift through some of the faulty logic in them.
And compare them to what Scripture says,
Once a month, we dig into the Bible.
going through one book at a time,
One verse or phrase at a time.
exposing the truth in Scripture.
Truth Exposed. Hey, that sounds like a good name for a podcast. I like it.
How about explicit truth?
No.
How about naked truth?
No.
Check out Truth Exposed on the first week every month.
You missed something, Keith.
Our audio drama
As long as our Protectorate players have all their parts in.
and our lazy script department has the scripts ready.
Isn't that you?
Make that our hard-working script department.
Watch for new audio dramas on the third week of the month.
Quest for truth.
Because if it's true,
It's true inside the Bible as well as outside the Bible.
check out life-truth.com.
So, Judge Mershon, in the jury instructions, tells the jury, quote, in determining whether the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you may consider the following. 1. Violations of the Federal Election Campaign Act, otherwise known as FECA. 2. The falsification of other business records. Or 3. Violation of tax laws, unquote. So, wait a minute. Judge Mershon tells the jury that they must be unanimous in finding Trump guilty of one crime, which is to conceal another crime, but that second one is only a crime if they agree that it was unlawful means, and now they have to figure out what the unlawful means were, but they don't have to agree on that. The judge presents three possibilities, three theories that they can pick from. Now, the first one is the FECA violation. This is the campaign donation law, violating the limit there. So donations given directly to a campaign in excess of the lawful amounts. Seemingly, this theory would cover the hush money payments. They would qualify as campaign contributions in excess of the low federal limits at the time in 2016. So, if a juror in the jury goes with the first theory here, it's that the hush money payments were campaign contributions, and of course they would exceed the federal limit. And now the second theory, falsification of other business records. So, if falsifying business records in and of itself is a misdemeanor, does it now become a felony if falsifying business records are done with intent to do something by the unlawful means of falsifying other business records, which, of course, is a misdemeanor? So, remember, falsifying business records is a misdemeanor, and if the falsifying business records was done to conceal the crime of conspiring to promote an election by unlawful means, which itself is a misdemeanor, and that unlawful means for that was falsifying business records, which is a misdemeanor, then we end up with 34 counts of felonies. This is the theory being put forth by Judge Mershon. If someone falsifies two business records, could one then have falsified business record 1 with the intent to falsify business record 2? And could business record 2 in turn have also been falsified with the intent to falsify business record 1? We could see how we could go in circles with this one. In this case, Judge Mershon suggested that the misdemeanor of falsifying business records could be the unlawful means of election conspiracy, which was the other crime for which the first falsifying business records turns from misdemeanors to felonies. You follow me? And number 3, possibility that a juror can pick from these 3. as the theory for the unlawful means for the election conspiracy violation. And this one was violation of tax laws. And Judge Mershon didn't detail here specific examples, but I think he suggested that Trump's extra amount to Cohen to cover income tax payments that he would make was somehow a violation of tax laws. Now, this one is a little hard for me to grasp. So you can violate tax laws by giving someone extra money so that it becomes income for them, and then when they pay taxes on it, what's left over is what they wanted to get, or you intended for them to keep. I don't see how this violates tax laws. Anyone's free to pay someone, if it's a legitimate payment, whatever amount, and they pay taxes on that. Regardless of what one's intent is for how the taxes work, as long as they're paying the taxes on it and reporting the taxes, why is this a violation of tax laws? So, in case we lose track of the layers of the charges, the jury members could each pick one of three possible crimes I just detailed above: campaign finance violations, falsification of other business records, or violation of tax laws. Whichever one they pick, this crime would be the unlawful means to make Trump guilty of the misdemeanor of conspiracy to promote or prevent election. This, in turn, is the another crime that Trump attempted to conceal when he committed the misdemeanor of falsifying business records. So one crime, whether a felony or a misdemeanor, is the basis of a misdemeanor for which another misdemeanor becomes a felony. Again, pick a crime to be the unlawful means that makes something else a misdemeanor that then elevates another misdemeanor to a felony. So whether Trump is guilty of falsifying business records in the first degree depends on if he committed an election conspiracy misdemeanor, and that depends on each member of the jury choosing from among three theories about the unlawful means. Simple, huh? I'm sure it was quite obvious to any street citizen looking at payments to a lawyer for legal services that, oh, goodness, this was an evil misdemeanor done to cover up another evil misdemeanor of campaign conspiracy by the unlawful means of one or more of three theories, one of which is another misdemeanor of falsifying business records. This is a felon as clear as day. This tangled web of accounting misdemeanors was all an evil plot as clear as day to commit felonies. Someone toss this felon into a cage and throw away the key. Judge Mershon, further down, after talking about the theories for which the jury can pick for the unlawful means for election conspiracy, says, quote, "Your verdict on each count you consider, whether guilty or not guilty, must be unanimous. In order to find the defendant guilty, however, you need not be unanimous on whether the defendant committed the crime personally or by acting in concert with another or both," unquote. So the individual jurors don't even have to agree or understand all the specifics of what happened. They just all have to pick one of the three. So as long as all the jurors agree that Trump committed election conspiracy crime by unlawful means, for which the falsifying business records covered up, as long as they all agreed in at least one of these three, then they're unanimously agreeing that Trump's guilty of the first two layers. Have you ever seen a case like this before, I might ask? I haven't. Now, the jury instructions also make clear that the jury cannot rely on their own notes from the trial over their own mental recollection for deliberation. It must all be from their own recollection of what they saw and heard from the evidence presented in the trial. The notes can only aid in that, but their recollection must take precedence. However, for each of the three theories for the unlawful means for election conspiracy, the judge delineated various claims of evidence for each. I don't know how much of this stuff would have been in the jury's notes or in their recollection of what they heard in the trial. For the FECA violation theory, Judge Mershon implied that any payments in excess of the federal limit of $2,700. For the FECA violation theory, Trump's hush money payments would count as campaign violations and therefore far in excess of the $2,700 federal limit. For the falsification of other business records theory, Judge Mershon referenced specific bank records from Michael Cohen's activities or from Trump's tax forms that he gave to Michael Cohen for reporting his taxes. I guess the jury members didn't need to take such notes because the judge gave these notes to them in the jury instructions. For the violation of tax laws theory, the judge mentioned a specific check stub number on a specific date and asked the jury to consider if this was done with the intent to defraud that included an intent to commit another crime. Now, even if the jury didn't even remember what that check was, for the judge to reference it in the jury instructions, the jury might think, well, the judge thinks this check is relevant, so why shouldn't we? So much for relying on their recollection when the judge says, you might consider these lines of evidence to determine this, or these lines of evidence to determine that, for each of these three theories of unlawful means. Now, each of the 34 felony charges were account entries, all related to the same thing. Remember, all of this was related to a specific total amount that would be paid as hush money. There were 11 invoices, 12 vouchers, and 11 checks. What's particularly loopy in my mind about this is that there are only a total of 11 actual payments. The first is for $70,000 and the rest are all $35,000. The $70,000 one naturally combines two $35,000 amounts. The total is for $420,000, which includes enough so that when Michael Cohen paid taxes, that the net amount would end up being the desired amount to recuperate him for paying Stormy Daniels. Each invoice for $35,000 is a separate felony from the voucher for that same $35,000, and that is a separate felony from the actual payment check for that $35,000. I simply cannot comprehend this. This all seems like an egregious abuse of the intent of the statutes involved. Why would falsifying business records mean that the invoice for payment, a voucher for payment, and the payment check itself for the actual payment all count as separate crimes when they're all talking about the same money changing hands? This is like if there was a statute penalizing travel to escape justice. And imagine with me that the prosecution divides the travel into how many times you stopped at a red light, stopped to fill up the tank with gasoline, stopped for a restroom break, went through a drive-thru to get meals, stopped at a hotel for the night, or any other interruption to the vehicle continuing to move forward as separate violations of this law. And each one of these carried the penalty specified in the law, and then you add all these up to one monstrous penalty. The New York statute says the crime, singular, of falsifying business records, plural, and that, quote, falsifying business records, plural, in the first degree is a Class E felony, singular. Now just think with me, if Trump had paid Michael Cohen in one lump sum, it would have been one felony. But since he committed the unspeakable deed of splitting his remuneration into several payments, each one of these becomes a separate felony that technically could increase the penalties 34-fold. Supposedly, the maximum penalty for these 34 counts totals to 136 years in prison, virtually 2 lifetimes in prison for falsifying business records, for splitting a payment across 11 checks and the accompanying records. Makes sense to me. What's the problem? A good bit of sarcasm there. Also, I would like to point out that New York Code, section 175.10, always, and this is the falsifying business records code, it always refers to falsifying business records in the plural. Look it up yourself. I'll provide a link to it in the show notes. It ends by saying, quote, falsifying business records, plural, in the first degree is a Class E felony, singular, unquote. I am not sure why the 34 payment records would all be separate felonies if they're all related to the same alleged singular crime.
The Christian podcast community is a cohesive group of like-minded Christian podcasters proclaiming the truths of Christ with expertise and passion in the areas of theology, church history, Christian living, evangelism, apologetics, parenting, homeschooling, sermons, and much, much more. So check us out at christianpodcastcommunity.org. christianpodcastcommunity.org. One stop for all your favorite Christian podcasts.
Now, after all my ranting about the strangeness of all these charges, let's get into the deliberation from the jury. On Wednesday, May 29th, the jury began deliberating. After 4.5 hours, they were dismissed for the day at 4 p.m. to resume the next day. While the jury were deliberating on Wednesday, Trump seemed to accept that he likely wouldn't be acquitted, that he would be found guilty. He called it a, quote, very unfair trial, unquote, and that, quote, Mother Teresa could not beat those charges, unquote. The jury wrote a request to the judge to hear a transcription read from witness testimony that would last about 30 minutes. The jury heard the transcript read the next day, Thursday, May 30th. They also had part of the jury instructions read aloud. Around 5:05 p.m. Eastern Time on Thursday, May 30th, the jury read the verdict finding Trump guilty on all 34 counts. As the verdict was read, it would mention each count, each charge, and then they would read the verdict guilty for each one by one. And I read posts on X, formerly known as Twitter, that day of people so happy and so elated that it was like a jolt of glee each time they heard the verdict guilty read over and over again 34 times. District Attorney Alvin Bragg issued a press release later that day, and I'll provide a link to the show notes there, where he says, quote, Donald Trump is guilty of repeatedly and fraudulently falsifying business records in a scheme to conceal damaging information from American voters during the 2016 presidential election, unquote. You know, I would love to know why the Hunter Biden laptop controversy doesn't qualify as election interference. I know it's not New York, and I know it's nearly impossible to tie what happened directly to Joe Biden himself, because he didn't really have to do it. The regime did it. The mainstream media outlets did it. 51 former intelligence officials did it in a letter claiming that the Hunter Biden laptop story, quote, has all the classic earmarks of a Russian information operation, unquote. And I'll provide a link to that letter if you want to look at it from the 51 former intelligence officials back in October of 2020. Now, I mentioned people taking delight about the conviction, the verdict, and the trial. Here's an example of someone. It's an article by someone named Torre for the Grio, Grio, on May 31st, so the day afterwards. This article from Torre came out, and it's an article entitled, "It Makes Me So Happy to Write Convicted Felon Donald Trump." And I'll provide a link to that one in the show notes. So Torre in the article says, quote, "I don't think Trump receiving 34 guilty verdicts in his hush money trial would make me this happy, but it did," unquote. And Torre talks about how Trump is, quote, "such a horrible person," unquote, but he doesn't seem to elaborate on that. And because of how bad Trump is, Torre feels justified to say, quote, "I feel schadenfreude. I'm not above being petty because it's human to enjoy another person's misfortune," unquote. He also says, quote, "I'm happy to see a black man like Alvin Bragg succeed. I almost never root for the government, but in this case I had to. For a black man, rooting for the prosecution is like rooting for the evil empire. But if Trump is in the building, I'm rooting for the other team no matter what," unquote. Sounds like this person has quite the bias here. Torre also said in the article, quote, "I'm happy to see Trump having to worry about being sentenced to prison time. I don't know if he will be sentenced or if he'll serve time, but many people seem to think that's possible. So until his sentencing date on July 11th, Trump will have this giant stress cloud hanging over him. He will have to worry that he could be sent to prison. I love that for him," unquote. So, sent to prison for what exactly? Did Torre even read the jury instructions to understand what exactly the charges were and how convoluted they were, like we looked at here? Does he get happy whenever a thief or murderer gets a conviction, regardless of who it is and what the defendant's ethnicity is? So exactly what makes Trump such a horrible person in Torre's eyes? Is it just politics? And does Torre, in all his joy about Trump getting a conviction, think that the actual conviction and the charges themselves were just? Or is it just if, as he says, something bad happens to Trump, regardless if it's actually true or not, or just or not? Now, on June 7th, Judge Merchan sent out a letter to attorneys from both sides of the case, and this was about a week later after the verdict, because a member of a Facebook group whose handle was Michael Anderson posted there on May 29th. And that was the day the jury were deliberating and the day before the jury reached a verdict. So this Michael Anderson's post showed that he claimed to know someone on the jury. Anderson wrote, quote, "My cousin is a juror and says Trump is getting convicted. Thank you folks for all your hard work," with 4 exclamation points, unquote. Various calls for mistrial abounded after that, including by some conservative commentators. And it still remains to be seen if anything will come of that or if anything was disproved about that. Now, sentencing was scheduled for July 11th, which was 4 days before the Republican convention. That was until July 1st, when the Supreme Court ruled in Trump versus United States that a president has broad immunity for official acts and no immunity for unofficial or personal acts. And it says in the ruling there held, "Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts," unquote. Now, naturally, the media threw a hissy fit over this as they understood the ruling or pretended to misunderstand it, or whatever the case may be. They were not happy with this ruling and had all kinds of claims about what it meant that Trump would be able to do, or even President Joe Biden would be able to get away with and allegedly be immune from it. But nevertheless, because of this ruling on presidential immunity, Judge Merchan moved the sentencing from July 11th to September 18th. Now, after the trial, Trump's team requested to lift the gag order because the trial had finished. However, Judge Merchan, Colangelo, and the appeals court refused to lift the gag order, claiming that Trump might threaten witnesses and jurors. Because Trump was scheduled to debate Joe Biden on June 27th, some people wondered if the gag order would become a tactic to try to bait Trump into answering questions in the debate that would make him violate it and get into legal trouble. But thankfully, on June 25th, 2 days before the debate, Judge Merchan partially lifted the gag order such that Trump could talk about witnesses and the jurors anonymously, but he couldn't make their identities public. Now, if you followed the news and watched the presidential debate and the aftermath and the assassination attempt on Trump, which I did an episode about, and the Democrat coup to get Biden to drop out, and the coronation of Kamala Harris to be the nominee at the top of the ticket, all of that could command several episodes of Truth Espresso. I mean, remember all the controversy about what happened in the assassination attempt and what happened with Secret Service Director Kimberly Cheadle and how she ended up resigning, and then all the questioning of the acting director and stuff like that. All of this stuff could command several episodes of Truth Espresso. But after all that, on Thursday, August 1st, the New York Appeals Court refused to lift the remaining gag order on Trump until sentencing in September. Trump's attorney, Todd Blanche, complained that Kamala Harris had been campaigning against Trump with statements about his position as a felon, and Blanche believed that the remaining gag order would prevent Trump from being able to rebut the attacks when campaigning for president. I'll put a link to an article about that in the show notes. As of this recording, Judge Merchan is supposed to issue a ruling before September 6th about if the Supreme Court's ruling on presidential immunity affects the verdict in the New York case because the payments happened while Trump was president. We shall see what happens. Somehow I suspect that he will say that the verdict still stands, and he'll argue that the payments that Trump made qualified as personal acts and were not and wouldn't fall under the absolute immunity for actions within his constitutional authority or his official acts. We shall see what happens there. So, that brings our series on Manhattan Madness, the New York Trump trial, to a conclusion. 5 episodes of digging into details, and I assure you I left out plenty. Has justice been served in all this? Perhaps you be the judges and jury in all this. I will reiterate that I don't believe Donald Trump is a clean man or has lived a morally upright life. I've said that, and it's possible that some of these allegations against him could be true. I think that much is clear, at least from things that he did in the past. I still can't vouch for how truthful any of the claims from witnesses in the case were. It's hard to trust any of the actors there not to lie under oath. What I can say about this is that I have serious doubts about if the actual charges from Alvin Bragg and for which Trump was found guilty were done in good faith. I think I have made that clear in this episode. I have no idea how trustworthy the jury was in this unprecedented case. I don't know if that Facebook poster claiming to be the cousin of a juror was true. It seems like Trump's guilt or innocence is currently most determined in the court of public opinion, and that was true before this case and after this case. Justice shouldn't be about politics and hoping something will stick and just wanting someone to get what's coming to him. The punishment must fit the crime, and the crime must be legitimate and biblical, and the crime must be proven beyond a reasonable doubt. If Trump really did something egregious, that should be tried. I don't like political lawfare regardless of any sentiments. No one should take glee in anything without vetting truth and true justice. And I will close with some verses of Scripture. Proverbs 25 verse 2 says, "It is the glory of God to conceal a thing, but the honor of kings is to search out a matter." It is something that, because we're not God, we actually have the honor and the privilege of searching for the facts to try to determine the truth, and that's something that we should do in matters of justice. Leviticus 19 verses 15 through 18 says, "Ye shall do no unrighteousness in judgment. Thou shalt not respect the person of the poor, nor honor the person of the mighty, but in righteousness shalt thou judge thy neighbor. Thou shalt not go up and down as a talebearer among thy people, neither shalt thou stand against the blood of thy neighbor. I am the Lord. Thou shalt not hate thy brother in thine heart. Thou shalt in any wise rebuke thy neighbor, and not suffer sin upon him. Thou shalt not avenge, nor bear any grudge against the children of thy people, but thou shalt love thy neighbor as thyself. I am the Lord." And this prescription of law seems like it would fit for the United States of America, but unfortunately it seems like we have lawfare, we have grudges, we have talebearers, we have hate. People who don't care if this is actually true, but just want someone to get what's coming to them because they don't like them. And that's not justice. So I leave this in God's hands. And I hope that this episode was beneficial if you've had some interest in this trial but might not have really looked at it in depth, and that I hope that this clarified or cleared up any understanding about what the charges were, what the verdict was. And it is quite a convoluted set, a tangled web there. And stay tuned for the next episode of Truth Espresso, and God bless.
Thank you for listening to this episode of Truth Espresso. Be sure to subscribe and rate it on your favorite podcast app. Truth Espresso is a member of the Christian podcast community. Check out other great faith-building shows at christianpodcastcommunity.org.